My Lord, there's a lot of havoc that operations of Galamsey, for example, are wreaking on our environment and our society. Going where you are going, what do you think should be the judiciary attitude to cases involving Galamsey? So far, it doesn't appear to be deterrent or exemplary enough to take people off this rather very bad practice. What do you think should be your attitude towards the practice, the menace?
Thank you, Honorable Chair. I would say that at least at the Supreme Court, the question of trial of Galamsey cases doesn't arise because the Supreme Court is not a trial court in that sense. So the Galamsey cases will not come to the Supreme Court. But I agree with you, the havoc being done by Galamsey, and I think that the attitude of the judiciary, where the evidence is produced and the accused persons are found, for the judiciary to impose harsh sentences. That one I agree with you entirely. Because of the environmental hazards, the damage, the destruction that are being caused to our environment, to our river bodies, to the farmlands across the country. But the Supreme Court doesn't hear the Galamsey cases as a trial court. Thank you.
Yes, Obama.
Thank you very much. Congratulations, my Lord.
Thank you.
My Lord is a lover of jazz music. I could read from your CV. And who is your favorite jazz person? If I may ask that before the major question. Are you the chair?
I took the jazz actually from the University of Ghana, from a friend of mine. My favorite jazz musician was Bob James. Bob James.
Thank you, my Lord. I've seen that you've attended a lot of seminars, some of which includes the Maritime Law Seminar. Recently, Ghana has been having some maritime disputes. And we recently resolved the one between Ghana and La Côte d'Ivoire, which we were successful. I know of some discussions going on between Ghana and Togo on some of the same maritime matters. What do you think account for some of these issues that takes us to the international courts? And what are some of the advice you would want to give to people within the space to enable us achieve successes when some of these issues arise? Thank you.
The Honorable Chair, thank you. The disputes, particularly with the area of maritime zones, mostly has to do with energy and the discovery of energy, oil, gas, and where exactly the boundary, for example, the one between Ivory Coast and Ghana, where does Ghana's territorial waters end? Where does the territorial waters of Ivory Coast begin? And of course, there's also the question of the technology in oil, how deep and slanting. There are very technical things that, I don't remember, if you look at the Ghanaian delegation that handled the case you talked about, the Ivory Coast, Ghana oil maritime dispute, there were people from across all areas, very technical people, because it's not simply a question of the sea. It's not like line, where you can easily draw a line from A to B. Underneath the sea, you don't know what goes on there. And that is what creates a lot of those problems. So I think that what we have to do is the current discussion, like you say, we're having between Ghana and Togo, in spite of the difficulties of demarcating the maritime boundary, for us to sit down, settle, and properly, even it doesn't matter how much it costs us, to properly demarcate the maritime boundary so that issues like the discovery of oil, the discovery of gas doesn't get us involved in litigation as happened in the case of La Côte d'Ivoire. Thank you.
Chair, my Lord, there's been issues regarding the chieftaincy institution. The Constitution has provided for that institution. But lately, conflicts in Boko, conflicts in parts of Ghana, utterances among some chiefs is creating some tensions within the country. I know amongst the jurisdiction of the Supreme Court, that you have the final jurisdiction when it comes to matters emanating from the judicial committees of the House of Chiefs, National House of Chiefs. We don't have a lot of chieftaincy institutions or skins codified. Some of the judicial committees are not properly represented. It's a source of worry, and I believe that some of the decisions that the Supreme Court has taken has also created some tensions within some of the traditional areas. You rightly said, based on facts before you, based on the law, based on evidence. But I haven't seen a lot of training activities, I may be wrong, with regards to the knowledge of judges, with regards to enskinment and stillment and customary law practices within certain areas. Do you find that as a source of worry, that judges ought to be brought abreast with some key traditional authorities and their traditional practices, especially in some parts of this country where we have issues? Thank you.
Thank you, Honorable Chair. The chieftaincy is itself, in some areas, a very emotive issue as to who is the proper person to be on the stool or skin, which family is or are the rightful people to nominate somebody to be on the stool. And these are the real issues that cause confusion. Somebody is not, he doesn't belong to the skin or the stool or the gate. That has to be, if you like, have to be installed, and yet wants to be on the stool, wants to be called the chief, he wants to be called Nana. Those are the issues that create chieftaincy issues. As for, and the Constitution has the Constitution makers found it necessary to reserve the determination of chieftaincy issues basically to the chiefs themselves, from whatever level, traditional councils, regional House of Chiefs, National House of Chiefs. The only time when the Supreme Court comes in, as you rightly said, is when an appeal is from the Judicial Committee of the National House of Chiefs. So we, as a judiciary, do not have much to do with either the enskinment or installment or destulment of any person. We do have, not too many actually, but I do know that some of our judges have been participating in seminars with the regional houses of chiefs. But I haven't participated in any seminar involving the issue of chieftaincy. But that is certainly because a lot of chieftaincy issues are left to the chiefs themselves to determine under this Constitution.
Thank you. I know recently one of your own was elevated by the Asante Hene at Suma. Congratulations to Justice Ankama. But, my Lord, society is evolving and very fast, and rightly so, my Lord. You have issues of artificial intelligence. Recently, I just read that WAEC has cancelled the results or suspended the results of some students who use AI to answer some questions, suspected, allegedly. You go to some of our law faculties, it's there, and grandfather, we call it. We are producing all sorts of materials within society based on shortcuts to learning. It's a source of worry, especially even members of the bar. Issues of LGBTQ plus issues. Recently, Parliament approved the regulations to support the production, sale, and processing of medicinal cannabis. Society is fast evolving. What are some of the things you will recommend or see the bench to take a major shift to when some of these issues come before you? Because society, like I rightly said, is fast evolving or changing. Thank you, and congratulations.
Thank you. It's a very broad question.
Was here. I'm sorry, I was distracted. Yeah, let me hear you first.
Yes. It's a very broad question, but the judiciary is not also at a standstill. We also want to move with the times. AI, of course, that's a very advanced form of IT. People are doing all sorts of new areas. So what we are trying to do to try to catch up is to do the issue. We have the issue of e-justice, computerization. Those are the areas that, but with respect to other areas, as and when the law changes, the judiciary will move in tandem with the movement of the law. As and when the society moves, the judiciary will move in tandem. We will not be at a standstill because we ourselves are also part of society, and we do not intend.
My Lord doesn't want to move before these things catches up with the judiciary.
Well, sometimes you move and slip. It's better to be in tandem with rather than to move ahead and then slip.
Yes. Thank you, my Lord. Congratulations. I see Kofi Boa here, Deputy Minority Leader from Elembele. I don't know, you are the reason why he's here. Your MP is here, Ama Kofi Boa. He hardly appears.
Oh, okay. Honorable, maybe yes, that's correct. He's the MP of my area.
Your MP wants to congratulate you here, but I say that after the proceedings, I'll give him the space. I want everybody to see that he's here to support you. So it's no use against him there.
Thank you, Honorable Chair.
Yes, Honorable Zuzu first.
Thank you very much, Honorable Chair. My Lord, congratulations once more.
Thank you.
I've seen that you've played some very, very key roles in your capacity as the President of Association of Judges and Magistrates of Ghana, and you've also played some very key roles on the Commission on Human Rights and Administrative Justice. And so my issue will be bordered a little bit on human rights generally in Ghana. What would you consider as your assessment of human rights practice, human rights promotion in Ghana generally, particularly because of your background as someone who has worked at the Office of Commission on Human Rights, Administrative Justice, all the way to the regional director level?
I think the Constitution has a wide range of provisions dealing with fundamental human rights, all provisions. The question is how the population seeks to enforce these rights. But I think that generally there is no I would say that from my point of view, there is no general violations of human rights. But where people's human rights are violated, they have access to the courts, they have access to the Commission on Human Rights, they have access to legal aid and other things to ventilate whatever grievances they have. And I think that we are not doing badly at all in terms of the area of human rights protection and the defense of human rights. I know where Honorable Member is coming from, so I understand. But I think that as a country, we are not doing badly at all in the area of human rights protection and human rights adjudication generally. Thank you.
My Lord, what would you consider as a general protection of human rights? Because in recent times, there are several stories of, for example, the military brutality in Ashaiman. We've had issues of police, extrajudicial killings. We've had several reports in recent times of different levels of violations. So I would consider these ones as real violations generally in that spectrum. So because you've been at the Commission on Human Rights and Administrative Justice before, would you not consider these matters as matters of human rights violation generally in our country?
My Lord is asking you kindly.
I've heard a lot of talking like crows. That's why I've kept quiet. No, the human rights, as I said, generally, we are not doing badly. Sometimes you can have exceptions. Some policeman will pick a gun and do something that is not allowed, shoot one or two people dead. That is a violation of somebody's human rights. The military, I know you talked about the Ashama, but I know that some of those things are investigated, but I don't know whether the investigation, the report has come to you or to, I don't know. But they are not, as I said, we are not doing badly. If you have one or two exceptions, people going about doing what they are not supposed to do, that I don't consider as a general perception of violations of human rights.
Thank you very much, my Lord. My Lord, I think in an earlier answer to questions posed by Honorable Godfred Gisao, you had said that a number of cases are handled by the judges, and most often than not, people do not appreciate all those cases, but usually have problem with the very limited political cases. And should we be worried that Ghanaians generally, either rightly so or wrongly, has misjudged the conduct of judges in those matters? And what do you think that, even as a Supreme Court bench, we can do to correct these perceptions?
Honorable Member, perceptions are generally difficult to deal with. Those are the mindset of some people. Now, people go into court to file cases with their own sense of what they expect, irrespective of the evidence, irrespective of the law. That's where the problem is. A lot of the times, some people don't even appreciate the issues. All they know is that this political party, this politician is going after this one, and that is all there is. As to what the real issues in controversy are, they don't even concern themselves with. All they know is that this somebody I follow in politics and he's being attacked by this man, rightly or wrongly. So if the judgment doesn't go the way he expects, naturally, but wrongly, he will proceed to shout from the rooftop that justice has not been done, this person has been cheated. And that's why I said it's difficult to deal with this kind of perceptions and to say that I will try to, as it were, sweep perception out of the perceptions are in the minds of people, and it's difficult to deal with. Thank you.
My Lord, finally, do you think it's time for us to have a Contempt Act where we can, by law, regulate the remit within which the court exercises its discretion to hold persons for contempt of court, right from the lower court all the way to the Supreme Court?
Honorable Chair, I don't think that there should be a law, as you have now in UK, for example, on contempt. But in all honesty, how many contempt cases comes before the courts across the country in a year? Very few. And where people make so much noise is the contempt involving the media. Seems to me that's where the problem really is. People say, oh, this media house, this journalist is being, but judges are attacked, people are hounded, they use all manner of strange language. And the court has no, if you like, we don't carry guns. The only power a judge has, and that is used, it's not something that we use, every day. Once I don't even remember for the number of years that I have sat as a judge to have convicted somebody of contempt. And I know a lot of my friends, my colleagues have the same attitude. But sometimes people should also be able to control their emotions, their language, and recognize that judges are also human beings. You attack, you hound, you insult. It's a way of making sure that such a person is brought to justice, to know that at least, even though we don't carry a gun, that is the only way we can also. Yes, that's.
That is your gun.
I don't think that there should be a law.
Very well, my Lord. Thank you very much. Congratulations once more.
Thank you. Thank you.
Honorable Brother Champong, do you still want to ask a question?
Thank you. Thank you, and congratulations, Justice Henry Anthony Kofi.
Thank you.
I see that you started off in Bibiani, and then for primary, Methodist Middle, Enyinasi in Elembele, Navrongo, and then University of Ghana Law School. I see the routes to entering law school were at the time from very difficult terrain. So I want to congratulate you for coming this far.
Thank you. Thank you, Honorable Member.
My first question is, coming from Enyinasi, I know in Lembele there have been some prominent people that have come up on the law trajectory. But from Enyinasi specifically, are you the first one to reach the Supreme Court?
Yes, I would say so. I would say that from Elembele, from the whole of Elembele, I will be the first.
From the whole of Elembele?
I would say
well,
so.
How about Elembele Blay, Freddie Blay? You didn't go to the Supreme Court. So oh wow, so Elembele must be very proud of you. Now, following from my senior's question on society evolving, are you familiar with the Gen Z?
The what?
Exactly. That was the point of my question. Gen Z.
I can't get the pronunciation correctly.
Gen Z.
No, I don't know what it is.
You do not know Gen Z?
I do not know what it is.
Okay. All right, those are people born between 95 and 2010, that generation.
95
and about 2010.
Oh, okay.
We call them Gen Z. Now that's how they are called. But that's actually my point.
Honorable member.
But that's
Honorable Member, for our record, you have introduced a lexicon that is not known to the Queen's English, which is our. So, what did you say it was for the record? Kindly spell it.
Gen and Z. Gen Z. You can Google it.
There's no EE after it.
No.
So
It's
how does the
Generation
Queen's
Z.
English pronounce GENZ as Gen Z? That's
It's-
not the Queen's
it's
English.
Gen
So it's
and Z. But it's pronounced Gen Z.
very well. For the record, let's make sure that he meant GENZ.
Right. But Mr. Chairman, that's exactly my point. That society is fast evolving. And for a lot of people, even around this side of the table, are hearing Gen Z for the first time. So I can imagine what is happening on my right side, where I see the Supreme Court judges. Society is evolving, but our laws are not. Maybe they don't have to, because crime is crime regardless of the generation that one was born in. But there are some lifestyle changes that come per generation. And I want to ask if it is about time. And by the way, e-justice and all those things are just efficient ways that the courts will help you perform. But the law itself, because of the lifestyle changes and the way some of these people behave, are you prepared to lead some reform in the law and some reform in thinking on how the courts see these generations? Sometimes the way you even dress to court in itself, you are guilty. Perception. So are you prepared to lead such a transformation, to get ahead on time on how some of our young people are behaving? Thank you.
Thank you, Honorable Member. The Honorable Member, as you know, the judiciary is not involved in lawmaking. That's entirely the remit of this committee and the House, the plenary, if you like. So the judiciary can, at best, where in a judgment, the judge or the court finds that there is some area that needs reform, make a recommendation. It is done all the time. The court can make a recommendation that such and such an area of the law needs reform. There is even a law reform commission. You could even make a recommendation to the law reform commission to look at this area of the law and see whether this is not an area that can be reformed. But the judiciary, as an institution itself, does not engage in law reform unless in some area where there's some judicial activism, but that is very rarely done. But essentially it is the remit of you, the legislators, to make laws for the country.
Very well. So in effect, if this side are educated on Gen Z, this side will interpret Gen Z.
Yes.
Very well. My final question is on certain time limits on cases. So, for example, we say contempt. When you bring a contempt case from filing to its discharged, should take 2 weeks. If it is a murder case, it should take 1 month. If it is a land case, it should take 3 months. So that people don't use the courts to stop progress, to waste time, because they know that all you have to do is to file something and then they buy themselves some time. Is it possible that we can reform our course to set time limits so that you know that when you take a particular matter to court, you know that at least in a month, in 3 months, this matter is closed? Is it possible? Can it be done?
Honorable Chair, that's a very difficult to say that this is a land matter that is being filed, and this land matter should be disposed of in, say, 6 months. Even let me give it a longer time, 6 months. Now, the adjudication process does not involve only the judges alone. There are all sorts of players involved in the adjudication process. What we are trying to do is to speed up the process, the procedure, like changing the way of giving evidence, timelines for taking evidence, timelines for judges to give judgments and those things. But it's difficult sometimes, land matter encompassing an area of, say, 100 acres, to say 6 months. The best you can do is to give some timelines. Indeed, 1 week, 2 weeks, 3 weeks, plaintiff, call your witnesses within this number of days, this number of weeks. Defendant, call your witness within this number of days, this number of weeks. But it's difficult right from the beginning to say that this land matter should take 6 months, this land matter, this criminal matter should say take there's a conscious effort on the part of the judiciary to speed up the process. But as I said, we are not the only players in the adjudication process. And sometimes, if a lawyer comes to court and says that I'm very sick, and he brings a medical report, what can the judge do? You can't say that there's a medical report that you are sick, but I want you to go on. The judge will be seen as being unreasonable. That's the language that they will use. So sometimes these factors have a role to play in the delay of cases. But it is not deliberate on the part of the judiciary to delay the hearing of any case that comes. Sometimes even the workload. If you went to a high court to see the number of cases before a judge in a day, you will marvel. Even as high as the Supreme Court, the number of cases, it's strange. Yes.
A follow-up on that, and I'm a bit worried that we will leave here without any assurance that cases will be sped up. The Controller and Accountant General...
That's not what I said. What I said was that the judiciary is making a conscious, deliberate, conscious effort to speed up, but we cannot put a...
My Lord,
yes,
that is perhaps the best of the judiciary. We are talking about what is required, which may be more than your best in this case. We're saying that cases just take too long. And for me, by a lawyer coming to court to say that I'm not well, and therefore give me 2 weeks, give me 1 month, the Controller and Accountant General has never been sick, because every month we get paid. I mean, people who provide essential services cannot use sickness as an excuse. And so if, of course, in cases where you are talking about 100 acres of land, 200 acres of land, those are outliers. I'm talking about 1 plot, 2 plot here, which is a majority of the cases. Why can't those cases, the judge look at the facts, look at the land size and say that this matter, both sides should agree that should take a month? Because I know it doesn't work, but can it work? Can we make it work as a people? It doesn't work like that. But can we make it work?
Please, lawyers,
as a people?
leave your mouth out. Let him ask his question.
Well, I'm not talking as a lawyer.
The lawyers are laughing. Let him ask his question.
Because as long as we make our mind that it will not work, it will not work. But I'm saying, as a people, if we make our minds that it will not work because lawyers must eat, then it will not work. Do you understand? But if we want to free ourselves from the pile of files by speeding up the cases, by setting dates or timelines on cases, except for outliers, can we begin to do this? Is it possible?
Ask you a question? Yes, my lord. He says, can we do better than we are doing now?
Not the type of set timelines that honorable member is talking about. And whether the land is 1 acre or one, but you can have a 1 acre land where the evidence may even be I don't know how to put it, but the evidence will be more loaded than even a 10 acre land. It depends. It depends on a lot of factors.
My lord, may I ask? Trials are regulated by rules of court. The rules of court are largely designed by the judiciary in consultation or in concert with Parliament. From your experience, I know you as a practitioner, I've seen you as a judge, and you have been a human rights administrator. Now, from your experience, very wide and varied experience, could we do anything better or different from the rules of court we have?
We've come a very long way from the old days when you put a witness in the box to lead him in evidence. And that alone, at least in the days I was practicing in Kumasi, a particular lawyer would lead a witness in evidence for 1 week. Now we've gone beyond that. We are using witness statements. Even the application for directions, we've changed it. We are now, if you like, front-loading evidence, documents. These are all meant to speed up the process of adjudication. But you see, the procedure is such that you can't avoid rules of court. Well, if it's a criminal case, you have to use the criminal procedure. If it's a civil case, all the applicable rules of evidence, the rules of court, you have to use them. You can't run away from those ones. Yes, thank you.
For us, I'll give you, for those who have not been in the courtroom drama, they may find it difficult to understand the process. But let me ask you, I've front-loaded all my evidence. Is that all in the rules? Because I've put in my evidence. We call them statement of case. He has put it. Is that the end? Should a judge in the rules use that to make a judgment? Is that practicable? Is that what the rules require?
That is part of the beginning. I will put it, that is part of the beginning. It speeds up the process. But that does not detract from the fact that you have to mount the box and give evidence. Whether you have front-loaded your documents, your evidence, or that, somebody has to mount the box and to be cross-examined. Expert witnesses sometimes have to be called. And you can't run away. A lot of things come into play in the adjudication process. It's not simply a question of just front-loading documents and say that the judge, without listening to evidence, that is not evidence. It has to be admitted by the judge as part of the evidence, and then he will look at it, the record, the evidence, and then give the judgment. So the education process is a long and very tedious process, which we are trying to speed up. Thank you.
I'm just saying, I have a personal case. I was in court last week. For 4 sittings, the witness in the box has not come. We go, he's not come, he's adjourned. We go, he's not come. You can't blame the court. So the human part is not in the control of the court. How the parties, their witnesses behave, and sometimes even how the lawyers behave, is not in the control of the court. But you may proceed.
Thank you, Leader. I will end by saying that with the letter that I've seen from the Chief Justice, Her Ladyship Gertrude Tokonu, I see that she's prepared to lead change in our courts, and I'm encouraged that with a letter that I have also read about Justice Henry Anthony Kofi, that you've come thus far, and I believe that this House will be very kind to you, and that when you get the opportunity, support the Chief Justice to bring the change that we all require.
Thank you. You have
Thank
finished
you.
with your questions. Who of you came first? Yes. Yes. Zuera, yes.
Can you imagine that?
Go into
Good morning. Thank you very much, Mr. Chairman. Thank you, Mr. Nominee, and congratulations for your nomination. I will take you back to your CV, page 3, on leadership committees positions held. I see that between 2016 to 2017, and of course, drawing from Article 1464, you chaired a committee on impeachment on some judges. Would you say that our judicial system is plagued with gross misconduct, such that in a space of 2 years, you had to sit on a committee over 3 impeachment cases? And if no, how did we get here that in 2 years we got 3 cases? If yes, what could be the cause and what can we do to clean up the judicial service? Thank you.
Yes.
Thank you, Honorable Chair. I actually did not chair the committees. I was a member. And let me put that on record. The judiciary, I think the 2016, 2017, 2017 should not, just by looking at the years, give an impression that the judiciary is full of miscreants who are just up to cause mischief. No. A lot of the 2 or 3 of these cases that we handled, as I said earlier, had to do with the expose of Anas. That is why they all happen around the same time. It does not reflect on the nature of judges that we have. But when an allegation, a petition is filed against a judge, certainly it has to be investigated, depending upon the level of the judge, where in the hierarchy the judge is. These judges who were affected by this Article 146 impeachment were superior court judges. And that is why the committees, various committees had to be set up. But it is not a sign that the judges are bad. In fact, judges are very, for want of a better word, very good and hard-working. Well, all of us. It's a human institution, Jada, when I admit. It's a human institution. You can have 1 or 2 people causing trouble, but that is not how the judiciary should be seen and how judges should be seen. Judges are very law-abiding, honest, and good people, if I may say it. The 3 committees alone doesn't mean that judges are bad people. No. Honorable Member.
Would you know if there are any such committees pending now investigating any sort of petitions or misdemeanor as we speak here?
As we speak, I'm not aware of any Article 146 committee pending. Article 146 is used where the judge concerned is, this method is used when the judge concerned is a superior court judge. And I'm not aware that any such committee is pending as at now.
Thank you. I'll go to my second question. And my second question is about lately, and I'll take you to 2013 to 2021. At least we've witnessed 2 electoral disputes at the Supreme Court. to the extent that in the last one, which was the 2021 hearings, the judges, Supreme Court judges, gained the euphemism of United FC due to the way Ghanaians perceived the conduct and acts of the judges. Would you say that the Supreme Court has learned any lessons from those two electoral proceedings that you handled between 2023 and 2021, and how that will shape your thinking and maybe enhance the processes if in the future there is another electoral dispute brought to the doors of the Supreme Court? Thank you.
No, I don't remember. I am not a member of the Supreme Court. I have not. As I sit here, I'm a Court of Appeal judge. If this committee and the House gives me the nod, then I'll be I'll be a Supreme Court judge. Maybe from that perspective, I'll be able to talk. But I don't get the point about something FC. I didn't get the question number. Something FC. I didn't get it. In all honesty. Yes, I didn't get it.
Yeah. Oh, sorry. The unanimous FC. That's how the Supreme Court was labeled by the everyday Ghanaian, who keenly followed the proceedings of the electoral dispute.
I don't remember. It was labeled by an individual. Nowhere has the everyday Ghanaian. Please, kindly keep quiet. There is no everyday individual who has made any such comment. I always say that the politicians' judgment of the courts, not the politicians. And there's the everyday litigants' judgment of the courts. This one was one of the politicians' judgment, the unanimous FC.
And I'm sure he heard. Yeah.
It was all over. The fact that he made reference to what was all over doesn't mean
exactly. Anyway, so can I take my third question? Yeah.
Did he answer your question on unanimous FC?
No. He says he's waiting to get to the Supreme Court. Then he can.
Before you answer.
Yeah,
very well. So take your.
He can help them change and improve on the processes. Mr. Nominee, you were part of a 3-member panel that recently dismissed an application brought to you by the lawyers of the Asen North MP, Honorable Chieftaincy, for a stay of proceedings at the High Court. What was your legal grounding? Would you want to share with us for making that decision? And can you educate the public on how you arrived at the decision, as many people found it more political than judicial? Thank you.
If I recall, that case was a stay of proceedings application, if my memory serves me right. And a stay of proceedings, he said the criminal matter was proceeding at the High Court. And then he said he had filed an appeal, and then he filed this stay of proceedings, which had been dismissed earlier. Earlier one had been dismissed by the trial judge. And we, on the panel, thought that there was no merit in the application, and we dismissed it.
Yes. Yes.
Thank you very much, Mr. Chair. My Lord, I congratulate you on your nomination. It's been 25 years since you joined the bench as the Circuit Court Judge in 1998. So I think your appointment, your nomination is very well deserved. I'll go back to the point that was earlier made by my colleague, Honorable Brian Champon, the Minister for Agric, regarding the rates at which cases are disposed of. In a recent case before the Supreme Court, Boys 2 and Daniel Adokwe and others, the judgment was delivered, I believe, on 22nd March, and there was a recent clarification by the Supreme Court, again, on the same matter, on 14th November, about some lands, about 72,000 acre land, affecting 70 villages, 72,000 acres, affecting 70 villages. This matter traces its origin way back to sometime in 1982. 41 years now, the matter has been finally disposed of. Now, some rights have been accrued over the period. The matter that my colleague was putting across is about the fact that the longer the cases delay, the more likely that you are going to have, encumbrance and so on and so forth, which by the time that you deliver the judgment, you probably would have had, a very murky situation. Thank God the Supreme Court has indicated that those who are in possession or have legal title and so on and so forth can atone tenancy to the Boy family instead of the Numu Mashi. But then again, you agree with me that the case has taken an inordinately too long. 1982, finally being disposed of in 2023. Now, if you get the nod, some of these matters you explain, very ably how the processes have been, changed in a way that would ensure that cases are expeditiously dealt with. Some matters like this, how would you, for instance, facilitate earlier hearing and disposal of some of these matters? Thank you, Mr. Chairman.
Honorable Chair, I agree that 42 years is a very long time. I do not know the processes, how it came about that case took so long, if indeed it took 42 years. But I do know, as a matter of fact, that they were, that boys tool, whatever case, there were so many angles, so many, if it were ever, I would say so many tributaries, several angles to that case. And as I said, the issue of adjudication is not only that of judges alone. You are dealing with 72,000, Honorable Member says 72,000 acres, 70 or so villages. I must be very honest, I haven't read the judgment, but I've read excerpts from the press. There was an earlier judgment, and indeed there has been a clarification. Sometimes they have to do surveying, all sorts of things take place. And that accounts for the delay. Witnesses are not available. 72,000 acres from the beach to somewhere up. It's up to the mountains, yes. You see, I don't think that the judge sets out deliberately to say that I want to delay this case. It starts from the High Court. Sometimes there's a stop, there's a retrial, there's something happens. The trial process is sometimes very laborious and sometimes even frustrating for us as judges. But that is what we are saddled with. And then it has to come from appeal from the High Court to the Court of Appeal. That's a long process. From the Court of Appeal to the Supreme Court. Sometimes you can have a record, 15 volumes. I don't know whether Honorable Member has seen 15 volumes of Record of Appeal. 20 volumes of Record of Appeal. It's a very difficult difficult issue that we deal with. But as I said, we are trying to speed up the process of adjudication with the various processes that we've set in the judiciary, including the Lady Chief Justice, have set in motion. Thank you.
Thank you, Mr. Chair. The expeditious way that the Agric Minister wanted the cases to be dealt with will not favor some people. Because if you have gone to the law school, there's a story about how a gentleman, having been called to the bar, immediately went and disposed of a matter so fast. But of course, Mr. Chairman, there are currently 12 justices of the Supreme Court, if I'm correct about that. Now, over the period, we are always told that the Supreme Court is packed. The bench is packed. 3 nominations have been made by Mr. President to add to the 12. That will make it 15. If this committee finds, you good enough, and then recommends to the plenary for consideration. 15 justices of the Supreme Court. Would you consider that as too many, given the different sets of jurisdictions that the Supreme Court has? Article 2, Article 130, Chieftaincy, jurisdiction, election, petition, original appeals, and so on and so forth. I mean, all these jurisdictions for 14 or 15 justices and paneling differently at different times. Would you consider this as packing of the courts? Now, that will be 15 if you add 3 to 12.
Different environment, different systems. Last week, and I can say this, I was trying to call a Supreme Court judge on phone. When she eventually picked the call, at 5:30, he said, "My lord, I saw your call, but we've been sitting from 9 o'clock to 4:30. We had 29 cases." That's at the Supreme Court, not a High Court, not at the Court of Appeal. And if you look at the 12 that we have now, there are actually 2 panels, only 5. There are only 2 judges extra left. The Supreme Court sits 5. If they are dealing with a constitutional matter, 7. So with the 12, we actually have only 1 panel. 5 more. So the 15 is clearly, as far as I'm concerned, I don't understand what is meant by packing. But it's not packing. There are, as at now, the 3 that you are talking about, they have retired. And in fact, it's not 3, actually 4 retired. So if you leave the 3 who have retired, you have to fill the vacancy. Otherwise, the current crop of Supreme Court judges, very soon they will start falling off, given the volume of work at the Supreme Court and the jurisdiction. Because every case, and I can say this, every case that starts from the High Court now, about 90% end up at the Supreme Court. Because in our system, we seem to have an open door policy. Every case that starts from the Supreme Court, it could even start from the Circuit Court. District. And then you move all the way to the Supreme Court.
My lord,
in the US, you can't
this matter of the volume of work, the wide jurisdiction of the Supreme Court, every one of your colleagues that has appeared before this committee, and I've been on this committee for the past 15 years, every one of the judges that has appeared here has raised that matter. What, in your view? And then, coupled with the fact that the Constitution does not give any ceiling of how many judges we can have, but we, by our own practice and convention, are limited ourselves to 15 plus the Chief Justice 16. What do you think practically the judiciary can do to make the case for augmentation of the Supreme Court? Because at the time we started with 15, the population of Ghana has since almost doubled. The number of cases in the courts has almost tripled. And generally, the issues. So what do you think the Supreme Court itself or the judiciary itself can do to bring the matter up for further and better discussion?
Well, Honorable Chairman, it is not for nothing that the constitution makers left the upper limit open, so that as we go on, we as a people will make a determination as to whether 15, we are now at 15, 18, 20, 21 is a fair number. But you see, in the face of the discussion, I've heard a lot of people say that it's too expensive to maintain Supreme Court judges. I don't know. 12. 15 is too expensive. Now we are going to what? 18, 20, 21. I will not stick my neck out. We ourselves should it should be an open discussion. I don't think the judiciary should take it upon itself to say, give us 17 judges, give us 19 judges. We should make it an open discussion. We can involve the judiciary, we can involve the parliament, involve the executive, and then discuss it dispassionately.
My Lord,
yes.
Do you think that discussion should be started and done by politicians? My fear is that if politicians start it, it will not end anywhere. That is why I'm suggesting that. Oh yes, we know what is the right thing, but we will.
But from what we are saying, as you say, you have been here for 15 years. You know where
the bar, the bench, and the faculty. My Lord, I'm proposing the bar, the bench, and the faculty. We used to have that conference. The bar, the bench, and the faculty. Is that a matter that can be put up for further discussion at that level?
That would be a very good place to start the discussion from.
Very well.
So that nothing is read, no meaning is read into.
No political meaning
is read into it.
Thank you.
Yes.
Thank you, Mr. Chair. My last question, and my Lord, would you, for instance, be supportive of a move that will be initiated by the judiciary, for instance, proposing constitutional amendment for some jurisdictions to terminate at various points? Then when it comes, then other arms of government would also consider, for instance. And I'm happy you are being supported by leadership, the Chief Justice. So you submit a memo recommending, for instance, election petitions regarding the parliamentary elections terminate at the Court of Appeal. Then you can have other matters terminate at the Court of Appeals and at different places, so that we can find, a very nicer way of dealing with this matter. That's just the question. But the last point, Mr. Chairman, is that I see that you like walking from your hobbies. I think that is very good for you. Having, taking up this huge matter, you're going to carry plenty jurisdictions on your head. So you need to exercise. All right. How many kilometers do you walk per day?
7.4.
7.4. That's very impressive.
I did it with about 4 of my colleagues.
Well, I see a lot of justices walk around some particular area of Accra, and I see you too. I see you too sometimes. Thank you very much, Chair. I wish you well, and then Merry Christmas in advance.
You walks too.
I kind of follow. Just a kind of follow.
Yes.
My Lord, you made the point that Ghana is not like America in terms of the Supreme Court. But just for the education of the general public, you didn't really state the distinction. And I believe that the distinction is that not every case goes to the Supreme Court as a matter of right in America. The Supreme Court has the power to decide what case to hear and not to hear. But in our case, every case from the High Court goes as of right, and for the Circuit Court by leave. Am I correct? And also, when we go to Francophone countries, the Supreme Court has a constitutional court and a Supreme Court, even next door. They have a constitutional court which is different from their Supreme Court. So the constitutional court deals with constitutional matters, and the Supreme Court deals with other matters. Am I correct?
You are correct, honorable member.
And so it would be good to come from your mouth rather than mine. So if you can tell us the distinction.
No,
because as the chairman said, advocacy should come from you, not from us.
Because honorable member gave out the jurisdictions of the Supreme Court. I didn't think that I should have on that point. But carry on from where you ended. In the U.S., you know, the U.S. is a federation. So that's where you start from. Every state in the United States has a judicial system like we have here. From the High Court, they call it District Court, Court of Appeal, Supreme Court, to a Chief Justice. Every state in the U.S., the 50 states, from the smallest, Rhode Island, to the biggest, California, others, every state. So in the U.S., there are 50 state Chief Justices, 50 Supreme Courts, dealing with state issues, so that those cases will not find their way to the Supreme Court that we usually talk about, the 9-member Supreme Court. I call it the Federal Supreme Court. Very few cases get to the Federal Supreme Court. In fact, if it's a case that is meant for the state, you cannot move from the state judicial setup to the federal system. And as honorable member said, in the U.S., the Supreme Court can look at the list of cases filed and then say that this year we are choosing A, B, C, D, for the simple reason that these cases are the issues that raise case issues that have to be determined. An injunction application filed at the High Court, which is ruled that the judge exercises their discretion, goes to the Court of Appeal, it is dismissed. It goes to the Supreme Court. Stay of proceedings, the one that I was asked, stay of proceedings from the High Court to, at that time, what is happening is that the substantive matter is there, not affected. And the judges are concerning themselves with whether or not the interim injunction was properly granted or not. While the land matter itself, the boys' stool matter, it's lying there. And substantive matter. We do election petition, like we are doing. The election petition is for our Supreme Court. In the U.S., the Supreme Court technically doesn't handle election cases. Election in the U.S. is a state matter. The state court handles it. So when we start making this comparisons, and so the U.S. Supreme Court, they have 9. If you bring the old judges in the U.S. to the Supreme Court here, they will collapse, in all honesty. And they have research, even they have research assistants, they have clerks, brilliant people from top-notch universities assisting them. We don't have those systems here. So those comparisons, we shouldn't make them. They are just unnecessary in all respect.
Very well. Thank you. Yes, Honorable Suini. Yes.
Thank you, Mr. Chairman. Congratulations, my Lord. Mr. Chairman, I will use my first go to make a correction and also, if you permit me, seek 2 clarifications from the nominee. On page 1 of the CV, I see your hometown, Ainasi. And the spelling is A-I-Y-I-N-A-S-I. And that is the correct spelling because I've checked. But when you check on the next page, page 2, September 1970, July 1973, Methodist Middle School. The A is there, the I is missing. Then you have, so for consistency, I suggest that we correct that. My first clarification is also on your CV. When I look at the dates given from the time you started formal education, 1980 to 1984 are not accounted for. 80 to 84 are not, or they don't seem to be accounted for. I would crave your indulgence to the first page. Okay, so that's 84. So thank you. I think I just got that. 80 to 84, that's when you were in the law school.
Yes.
And 86 to 87, when you were at the faculty. 84 to 86 was when he was at the faculty.
84 to 86 was when I was at the law school. Actually.
The law school, yes. I got that. 86 to 87.
86 to 87, I was actually doing 86 to 88. I was actually doing, I think it's an error. I was doing national service.
Okay.
86 to 88, June. I was a national service person.
Okay, so that is not provided here. I'm sure that it will be helpful if you make that provision. Now, my first question. If you look at the letter that the president sent to Parliament, a number of things come to attention. The first paragraph, the last line, the president says there are now 13 justices of the court, including the new Chief Justice, Mrs. Justice Gertrude Tokono. That's the last line. And he's nominated these 3. Now, that will bring the number to 16. Because that's why, if you notice, when my colleague was saying 15, I said 16. Because the last line in the first paragraph says, there are now 13 justices of the court, including the new Chief Justice, Mrs. Justice Gertrude Tokono. No, the president indicated that these vacancies have occurred as a result of the mandatory retirement of Justice Nene Ofoi Amegache on 3rd February 2023, Chief Justice Enin Yeboah on 24th May 2023, and Justice Jones Doche on 8th June 2023. There are now 13 justices of the court, including the new Chief Justice, Mrs. Gertrude Tokono. So that's not really my issue. My issue is that in the second paragraph, he says, in order to fill these vacancies and reach the full complement of the court, and subject to the satisfactory conclusion of the processes set out in Article 1442 of the Constitution, the following persons. Now, my issue is full complement of the court. Because when I look at Article 1281 of the Constitution, it says the Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. Have we established a full complement of the court? And what is deemed as a full complement of the court? That the president has to nominate these 3 to fill up.
Honorable member, I don't know the date of the president's letter.
23rd October.
I know that in October, another justice of the Supreme Court has retired, Professor Kote. Probably that explains why Professor Kote has since, in fact, in October, he has retired as a justice of the Supreme Court. So probably we need to look at the numbers. But talking about full complement, I think for now, the convention seems to be around 15, 16. I think that's all that I will say for now.
Okay, so so the president could have chosen not to appoint anymore to replace these people. My issue is when he says that he needs to reach the full complement of the court, as if to suggest that there's an established number that should not be below, because the established number by the Constitution is that it should not be below 9. And so even if you have 3 going and you still have about 12 or 13, what does it mean to say to fill the full complement?
In answer to a question, I did say that the Constitution that talks about the 9 is the minimum number. There is no upper ceiling. But by convention, over the years, we are playing around 15, around 16. Probably that is what informed the president's choice of words, the full complement of words. But the workload, I've already mentioned that the workload is such that 12 will just not be adequate, given the workload at the Supreme Court. We probably need to, if we want to make a good argument, we need to look at jurisdiction of the court, actually.
Okay. My Lord, I also see on page 3 of your CV, that as part of some of the leadership or committees that you served in, you indicated that in 2016, you served on the Article 146 Committee for the impeachment of Justice Ringo. May his soul rest in peace. 2017, for the impeachment of Justice Charles Quist, and the Committee for Impeachment of Justice I.C. Addo. You also earlier, in an answer to a question, said that some of these, or many of these, were as a result of the Anas Amiyao Anas investigation. Now, based on the work of Anas Amiyao Anas, you served on these committees and recommended the suspension of some of these justices. Recently, a colleague judge described the work of Anas Amiyao Anas as investigative terrorism, called him an extortionist, a blackmailer, and evil. How does that make you feel, knowing that based on his work, that is now described as investigative terrorism by a colleague, you recommended the dismissal or suspension of some of your colleagues?
Thank you. Honorable Chairman, I know that that judgment you are referring to is a subject of appeal. I know. It is even the subject of a judicial review application before the Supreme Court. So I will not be drawn, I do not want to be drawn on that issue. As to how the judge described that, I don't want to go there. Because it is the subject of a judicial review application before the Supreme Court, and it's also the subject of appeal at the Court of Appeal.
But, my Lord, the real issue is, based on the work of that person, cut out the description, you recommended. What was the basis of your recommendation? Did he bring evidence that supports the law? Or that? I think that should be where your answer should be.
One of the cases had nothing to do with Anas Amiyao. The case of Justice Ringo, the one, honorable member, Ringo Kas Azuma, had nothing to do with Anas case. The two, Justice Charles Quist and I.C. Addo, had everything to do with Anas. But you see, a petition had been sent to the president. It had been forwarded to the Chief Justice, who had, as mandated under Article 146, done a preliminary prima determined investigation and come out with a prima facie case against these judges. And then based on that, the Chief Justice then constituted this 5-member committee, of which I was a member. These judges, Charles Quist especially Justice Isiado, he chose not to appear before the committee. So the committee dealt with the evidence before it. And we, based on that, recommended that he should be removed as a judge of the High Court. The same goes for Justice Charles Quist. He gave a power of attorney to the wife who gave evidence before the committee, and based on the evidence and the evidence before the committee, we found that he determined that they should be removed. The five-man committee determined that they should be removed.
So your position is that the evidence presented before you as members of the committee did not suggest that it was procured through evil, blackmail, and all that?
Honorable, please don't answer that one. His answer is sufficient. Those are your imputations, please. That has nothing to do. Please ask another question.
I know. Sometimes it's important we get educated and get the separation, right. But I'll move on. So he dealt with a separate evidence. What is before the appeals court may not be related to the evidence that he dealt with. But I'll move on. As president of the Association of Magistrates and Judges, I came across what seemed like a media bliss on how to interpret how to interpret and understand what Article 71 office holders get every 4 years. A statement was issued. Many news outlets carried it to say that justices of the Superior Court do not take ex gratia, and that what they benefit from are properly so-called back pay or salary arrears. Now, he issued that as a president of the Association of Magistrates and Judges. Now, that seemed to be the confusion in the minds of many when it comes to Article 71 office holders. And sometimes, because as members of Parliament, we stand to be elected, we find it very difficult to speak for ourselves. But does what the judiciary benefit from differentiate from what the politicians benefit from? That is those who fall under Article 71. What do you think about the discussion around the need to repeal that provision of the Constitution?
Honorable Member, you refer to a media blitz. That statement that was issued was actually in reaction to what was discussion that was going on that week about judges. In fact, they were specific. Judges taking ex gratia every 4 years. And that is what necessitated us to come out with that statement to say that judges do not take ex gratia every 4 years. And which is the correct position. As I sit here now, I am on 2020 salary. I don't know about MPs. I don't know about MPs, but as I sit here, I and all my colleagues are on the salary determined by the committee that finished its work in 2020 and came out with a salary. So as I sit here, including Her Ladyship, the Chief Justice, we are all on 2020 salary. 2021, 2022. We are in 2023.
Not even cooler.
Honorable member, you know that some people took cola. We haven't taken anything. So next, I know the president has set up another committee as required under Article 71. Now, if the committee comes out and says next year that in 2021, because obviously it has to start from 2020, in 2021, what you should actually have taken was this 5% over what you were taking in 2020. In 2022, 2023, 2024, that is how the progression is done. And then the difference is paid to me. That is what I should actually have taken. I think if we want to do it the right way, we should forget about this one,
my Lord,
and pay ourselves every year.
My Lord, you are preaching to the converted in this matter. We are all in the same super zone.
I'm very careful. I don't know about what MPs take. To be honest with you.
Mr. Chairman, so that is why I asked the question. Does what pertain with the judiciary, is it different? Is it different, per your knowledge, with what pertains with politicians? Because the thing is 71, and we are all 71, Article 71 office holders. So I like the way you have explained it. And like Chairman has said, it is the same thing that politicians also go through. And it is the same payment that is paid to the judiciary, that is paid to the politician, which is described as ex gratia. As members, it's the same calculation that is usually done. But I'm saying, if we have come to if you agree with me that what pertains with the judiciary is not different with MPs, and they're actually the same, what do you make of the discussion around the need to repeal that provision of the Constitution that they say gives Article 71 office holder special treatment, so-called special treatment?
You see, I'm very careful about, I don't want to wade into your conditions of service, because I don't know, in all honesty.
But it is covered by Article 71. It cannot be different. 71.
My Lord, Article 71 regulates all of. There are differences, though, yes, because we are contract employees and our term ends every 4 years. They continue and the progression and so on. So let's not hold on to what he may not know.
I don't know what you take.
That's right. Thank you. Honorable Kote.
Thank you very much.
Yes, Honorable Kote, please.
Thank you very much, Mr. Chairman. My Lord, Justice Henry Anthony Covey, my namesake, congratulations on your nominations. My Lord, I'd like to reiterate the position earlier made by my colleague, Honorable Hassan Tampuli. Having been the regional minister, land dispute matters is almost taking over the region, which poses as a security threat for the region and also Greater Accra, and also is intertwined with boundary issues. There are cases that have traveled well over 23, 24 years. And currently, as we speak, we don't have clarity, with the greatest of respect, on decisions or rulings by the Supreme Court as to a judgment plan that will, as it were, guide the security and intelligence agencies to implement. That is one. Now, like you rightly put, cases travel from district, high court, appeal to the Supreme Court. What will be your opinion? I know you've talked about the Supreme Court in Ghana and that of other jurisdictions, but isn't it about time that we find a way to curb this situation? And what will be your opinion?
Honorable, I mean the situation of delays, if I understand the question.
Is intertwined with long adjournments, delays in hearing and delivering of judgments.
Oh, the problem actually with us is not the delay in delivering of the judgment. It's actually the processes leading to the delivery of the judgment. That's where the delay is. As for hearing the case and fixing a date for judgment, there isn't much of a problem there. It is the processes, the hearing processes leading to the eventual determination of the case with the judgment. That's where the problem is. And I've already talked about how land cases by themselves create a lot of problems and how the judiciary has tried over the year, with the help of Parliament in terms of the rules, sought to amend the rules of procedure, even the rules of evidence, so that these processes can be speeded up.
Mr. Chairman, this is not my second question, it's a follow-up. My Lord, something is emerging again in Greater Accra that people, chiefs and traditional authorities, after so many years, will emerge all of a sudden and say they want judgments. And they go around places like Spinters, like Tema, where buildings have been there for the past 15 years and 16, 20 years. And they say they have judgments. And they come right on your walls and bring land guards to start pulling down people's... this is becoming worrying. And that's why I talked about the delay in delivery of judgments. Now, again, an event where this August House approves your nomination, do you think it's about time for the judiciary or the judicial system to work hand in hand with the Ministry of Lands and Natural Resources to look at land tenure system in this country? Thank you very much.
Yes, my Lord.
There's something the honorable members that I want to address. Said somebody coming after 15 years holding a judgment, fresh judgment or judgment that has been delivered previously.
My Lord, fresh judgment. My Lord, fresh judgment. It's happening around Spinters and all that. A particular group will come and say now they have won judgment and they are going after landlords and homeowners to say they have judgment.
No. Honorable member, every judgment can be traced. If you brought me this one as a judgment, clearly, the judgment should be able to trace what is the suit number, who are the parties, who was the judge who delivered the judgment, when was the judgment delivered, and then you go to the court, alleged to have made given the judgment, to trace the judgment, ask for a copy of the judgment. If you get a judgment, it is very clear that you can follow up, get the whole record. When did the litigation start? Who were the parties to the litigation? Who gave evidence? If you want the proceeding, who gave evidence in this case? How come I was not informed? How come? What was the description of the land? It is very easy. If people come out of nowhere holding a judgment and like this and say, this is the judgment.
My Lord, forgive me. I am not saying that these judgments are not true and same coming from a court of a competent jurisdiction. But I'm saying that as a result of the delay in delivering judgments, cases that ordinarily should have traveled maybe a year or two, travels 20, 30 years, and then you have people who have hitherto bought lands from a particular store, built and have their titles.
It's the same question that Honorable Brane Champong, the processes. And that's why I said, can we use the procedures in court to speed it up? But there's a limit. When you do not come to court, the procedure cannot force the judge. Those parts are difficult to be managed by the court. If you have another question, can the other one? The Speaker is asking us to suspend and come to the inauguration of.
My third question. My Lord, I know that you have a wide range of experience, having gotten to this stage, and you've practiced. So now that you are on the way to become a Supreme Court judge, should a case come before you and then not known to the public, but a party in the case may have been your client or a friend of yours, how would you handle the matter?
Oh, no, thank you, Honorable.
Saying if it's not known to the public, but to you, that person has been your client many years, or is even your friend?
No, I will recuse myself from the case. That is a very important tool available to judges, whether the other side knows or not. Being honest to yourself, you recuse yourself. Because otherwise, those sort of cases are the type that end up even giving you trouble. Because you know that the person is your client, you want to sit on it. You want to help the client. The case may be bad. What do? And then you want to, if you like, mutilate the case. I will recuse myself. And I think that is what most judges do. A lot of judges recuse themselves from hearing of cases. Sometimes when we do those ones are not published. Because they are not news. They are not news. We do a lot. Yes.
Mr. Chairman, thank you very much. Finally, I see the Chief Justice here, and once again, congratulations, Madam Chief Justice.
We haven't acknowledged her yet. So if you see her, keep it quiet. Honorable Amaboy, you want to say something quickly before?
Chairman, thank you. Mine is not a question. Let me simply congratulate the SCOFI on behalf of the good people of Elembele and the Western region. I know that his life journey and achievements should inspire every young person from remote villages and with difficult backgrounds. So, congratulations.
Thank you, Honorable Member. Thank you for the compliment.
All right. Honorable Ayaga, let me hear you, and then I'll come to leadership, because the Speaker wants us to come and inaugurate the Parliamentary Association. So let's get this done quickly, and then.
Thank you. Three quick things, quick. The first one is, and before then, let me congratulate you and follow the protocols. The first one is a follow-up on a discussion that has taken place already on the size of the Supreme Court and the comparison and the relationship that we have been making with countries that have constitutional courts and then countries that have federal systems and lower tier Supreme Courts. As a way out, is it possible for us to consider organizing our Supreme Court in 3 divisions? Because if you look at the Constitution itself, it talks about a supervisory jurisdiction. It talks about an original jurisdiction, and also talks about an appellate jurisdiction. Is it possible that we can enact a form of a constitutional court that focuses only on the original jurisdiction, which is basically constitutional matters and human rights matters and appeal from the High Court in human rights matters? Then also have an appellate jurisdiction that focuses on appeals only from, I see the CJ nodding her head in disagreement. The body language is, I'm receiving. So is it possible? I'm asking a question. Is it possible, looking at the language of the Constitution, and keeping in mind the battles that we fought in the definition of the fast-track High Court, whether or not we could, have a fast-track high court, whether that is a division of the court, even though in the Constitution it is said that the Chief Justice can organize a high court along certain divisions. Can't we also have the Supreme Court organized along those divisions so that people can understand the numbers?
Honorable Member, that wouldn't, for me, wouldn't make any difference. If we are dealing with the appellate jurisdiction, we are dealing with appellate jurisdiction. If we are dealing with supervisory jurisdiction, we are dealing with supervisory jurisdiction. If we are dealing with reference jurisdiction, we are dealing with a reference jurisdiction. It is the same number of judges who are going to sit, whether you call it a division, or the Constitution doesn't use division in terms of the Supreme Court. It doesn't use it. But whether you are doing reference, whether you are doing appeal from the House of Chiefs or whatever, it is the same number of judges who are going to, depending upon which panel is determining which matter. So it doesn't really make any difference whether we make it a division or what, but the Constitution doesn't use the word division in describing the Supreme Court. It is the High Court, the Court of Appeal has a criminal division, and then the High Court also has divisions, but the Supreme Court doesn't, there's no reference to divisions.
Yes, and earlier on you...
It doesn't make any difference.
Yeah, earlier on you said that as we grow and then the caseload expands and etc., we should have a conversation about how we deal with these issues in relation to the numbers. And just for strategic communication reasons, that if we organize ourselves along those lines, and then people know that there is a constitutional court that needs 9 people, there is an appellate court that needs the same number of people, there is a supervisory jurisdiction Supreme Court that needs these numbers, they can relate to those numbers. Otherwise, as we speak, every day that we vet a Supreme Court nominee here in this room, the issue comes up, and we're asking the same questions. Now, the second question has to do with your role as president of the Association of Magistrates and Judges of Ghana, a post that you've occupied since 2021. I want to understand, as president, what is it that the association, working with the judiciary generally, has done to deal with the perception that our judiciary is corrupt, the perception that Ghanaians have of the rule of law, that justice is unequal, that it is not accessible, that it is slow. And colleagues here have asked you variously questions. The regional minister just asked you a question about land issues and the security issues that those land issues relate to. Some colleagues here have asked you about the chieftaincy issues and the security issues and the delays in adjudication. What is it that, as an association, you can do to deal with the problem of perception of corruption among the judiciary?
Thank you, Honourable Member. The association, by and large, is actually interested in the welfare of judges, first and foremost. That is basically what the association is about. Of course, we collaborate with the Chief Justice, with the administration. We make suggestions for the improvement of the conditions of judges, especially the lower court judges, and make all sorts of suggestions. But the perception about corruption, I think I've said that, the perception, it's a mind issue. There's a lot of talk about judges, and with perceptions, they are difficult to deal with. We have seminars, there have been several seminars, not by the association, but by the judiciary, on corruption, on ethics. The judiciary has ethics, and as I say, we also have complaints. That is the work of the judiciary, and the judiciary has been doing it without fail. We have ethics, we train our judges on issues of ethics, on issues of corruption, on issues of proper behavior. At almost every year we do it. over and over and over. It is, the association has not basically set out to disabuse the minds of the public. But every time we have the opportunity, we tell people that is, the perception of corruption, it is, some of them are actually unfounded. Somebody goes to court, he loses a case, there's corruption. Somebody goes to court, he misconducts himself, something happens, there's corruption. Unfortunately, we as judges cannot sit and make press conferences and say that, oh, this is this is this. We don't do those kind of things.
Yeah, thank you very much, my lord. You know, we know it's perception, but you know, even Jesus had occasion to ask, "Who do people say I am?" Who do people say I am? So it is important that the judiciary should be concerned about what the public thinks about it, because you need the public to be able to have the legitimacy as an arm of government. You don't have a police force, you don't have the benefit of the treasury, you only have the benefit of public support for you. So you must always be concerned about who people say you are. My last question, tied to the question of who do people think you are, is, do you think that the judiciary should be more strategic in its communication? You know, I worked in the executive for a while as a minister for information, as a presidential spokesperson, and etc. Things don't just happen. Things don't just happen. They happen based on a clear communication plan. Does the judiciary realize that it needs to carry the public along with it? And therefore, in everything that you do, cases that you deal with that have, you know, public interest implications, that you must have a communication plan?
Honorable Member, I agree with you. Communication in this age is extremely important with social media, all sorts of media outlets. It's very important that we... I do know that the current Chief Justice, I've heard her opening new courts and telling people about the fact that we as a judiciary are against corruption. He's been saying it all. In fact, the previous Chief Justice was doing the same thing, talking about the fact that the judiciary is against, it's not a corrupt institution we are against, and people who have complaints should come forward. Of course, I agree with you that probably we need to look at our communication department. It's something I have personally also been advocating for, that we need a very strong communications, or if you like, public relations department to speak for us.
All right. Thank you, my lord. I want us to quickly go in, but let's close this one. So the Chief Whip will do the last one, then we can proceed to see Mr. Speaker.
Right, Honorable Speaker, Chairman. I know there are issues the minority leader wanted to take, but he's not here currently. I want to congratulate the nominee for his appointment to this high office. The first thing I've observed on his CV is that the GRA tax clearance certificate attached to your CV appears to have not applicable and nil everywhere. Do you earn any income at all?
Apart from my salary, I don't earn any other income.
Your salary is an income. But your salary, no. Do you earn any income at all?
Yes, for my salary, yes. That's my salary, yes. But that is paid at source.
So how come on your tax clearance certificate, 2021, turnover, not applicable, chargeable income, nil, charged, nil. Meanwhile, if you look at the other nominees, there are figures attached. So is it the case that when you earn salary from the state, your tax clearance should show zero in terms of your income?
I was asked by the GRA, and I sent the tax paid vis-a-vis the salary for the period. I submitted them, and then they came out with this and gave this to me. I didn't prepare it myself.
So did you see what was given to you?
I saw it, yes, ma'am.
And you saw that chargeable income, nil, meaning you don't earn anything? Because the tax is supposed to be charged on what you earn.
I assumed that they had taken into consideration the fact that the salary had been paid at source and that I had not earned any other salary.
I'm not talking about any other salary. It's any salary, any income. Because, in fact, GRA will compute the taxes on anything you earn. The leader is here, we take it from there. In your various answers to the questions about perception of corruption, indeed, you are not the only arm of government that suffers that, as a matter of fact. I don't personally believe every judge is corrupt or is up to no good. I don't believe that. Just as the way I don't believe every politician is up to no good. But there's a perception that is placed negatively on the executive, legislature, and yourselves. In all your answers, sometimes you give an answer suggesting that, yes, you agree you are a human institution that could be a miscreant. That's the same way there could be a miscreant in parliament or in government. But then on another leg, then you make it look like, we have the various ways of people reporting wrongdoing. Is it the case that you don't believe that there are judges that have misconducted themselves in reality, not perception?
Honorable Member, I've sat on a committee which has been referred to, which we have found judges have misconducted themselves. I don't deny that judges misconduct. Some judges misconduct. That's why I said that some miscreants. That's why I used, and some judges misconduct themselves. But that is not because another member said that, does it give the impression that judges are, that was why I answered and said it is not. These committees that I served on should not be used as an indicator that judges are corrupt and judges are bad. These were, if I, for want of a better word, these were people who fell foul of the law and they have been dealt with. That is not to say that moving from there, every judge therefore is correct. No, that's why I said yes. There are judges who misconduct themselves, but that is not what can be used bad or as evil or as whatever.
Actually, I agree with you. I don't believe there's any human endeavor that is just filled up with all bad people. Mr. Chairman, if you turn to page 4 or 5 of your CV, that table talks about conferences and capacity building things you've engaged in. Particularly on the 13th of June 2017, you attended a training which has got to do with mental health, suicide, and stress management for Supreme Court and Court of Appeal judges. What was the content of that capacity?
The content. But that was the area that was covered. That's what we've said. I've set it out. Mental health, suicide, and stress management. Our judges, our job is very, very stressful. And we thought we needed some education and some lecture on how to manage stress, how to get over suicide. We didn't say judges are suicidal, but just in case anybody has suicidal tendencies, and then mental health. Those are areas that we thought we should have some training on, and that's why we had those seminars. It speaks for itself.
What were some of the significant things you heard there that can help you in your new role as a Supreme Court judge with reference to this particular training?
Particularly with stress. As I've said, our job is very, very stressful. The workload, sitting down endless hours, day and night. We were trained on how to get over the stress, how to relieve yourself if you are under too much stress. And so, at the new level, I'm going to use the same training.
I actually like your idea of working day and night.
Oh, every judge does that.
Thank you very much.
Every judge does that.
Mr. Chairman, Mr. Chairman, when Honorable Ayariga was concluding, because Speaker suggested we need to go into the chamber, I will make it short. He gave some idea, his recommendation of the judiciary also taking steps to draw closer to the people to understand what goes on there. So the perceptions don't become the norm. I hope that is taken on board. But my last question, my first question was about your tax clearance certificate. We didn't finish that. Now the minority leader is a tax expert. It's an issue I think we need to look into. So, leader, because of time, I'll yield that to you. When I asked why his tax clearance showed 0 and nil for everything, I wasn't satisfied with the answers. Maybe I think you can take it from there. So, Chairman, just because of time, I'll end it here and sit to the minority leader.
Chairman, I will start.
Yeah.
Yeah. Good morning, honorable colleague, honorable nominee. Congratulations for your nomination. Thank you, honorable chair. Let me start with the issue before us. Have you been in any gainful employment since 2001? Since the year 2021. 2021. I've been a judge since then. And during this period, you are paid. That's correct, honorable member. Do you have a copy of your tax clearance before you? I have it, honorable member. Okay, so let me refer you to item 3. No, first item 2. This certificate covers personal income tax, PIT. And then item 3, below is a summary of income tax position for 3 years. 1, 2021, turnover 0, chargeable income 0, tax charge 0. Tax paid, 0. Tax outstanding, 0. Can you explain why, though you've been in an employment, yet there's no chargeable income and tax charge to date for 2021, 2022, and 2023? I was notified that I needed to produce tax clearance certificate. So I contacted our division. We have a division, a salary division, and they asked for my salary. I asked them to print the salary that I have for over a 3-year period. And then they took it and submitted it to GRA. They brought this to me. I didn't actually go to GRA myself. They submitted it, and then they brought this. And I saw Amisha Dai also and Amwa at the bottom. So I assumed that it was proper document coming from a proper source. Mr. Chairman,
Did you review this document before you submitted it to us? After you received it? Did you
I?
review it? Did you review the document, the certificate, or you read the certificate before you submitted it to us?
Yes, I saw it, Honorable Member. I saw it.
And you think there's nothing wrong with the certificate before us?
Yeah, because I had attached the pay slips, I had assumed that they had taken into consideration the fact that my salary had been deducted at source. So they were aware that my salary was deducted at source.
No, the question here is, if you had paid attention to the certificate that was issued by the Ghana Revenue Authority, you would have seen that there was something wrong with it. Because it says on the face of the certificate that between 2021 to 2023, you have not earned any income. Aside, you have not paid any tax. And that is why I'm asking, did you had an opportunity to review the document before submitting it to us?
I don't see where it says that I have not received any income, honestly.
Mr. Chairman, the document before us does not conform with the honorable nominees' employment status, and there's the need for GRA to resubmit the tax clearance certificate, or maybe the committee will have to write to the GRA to get them to conform, because what is before us does not qualify as tax clearance certificate, considering the fact that the nominee before us has been a judge since 2023. Chairman, I make the application before you. And then I move on to the second question. Justice Kofi.
Honorable Chair.
We do not seem to have any clearance from the National Investigation Bureau and the CID before us on the file, because ideally we should have it as part of the document before us, so we'll ask you some questions on it. Mr. Chairman, those documents are not before us, so it's difficult to ask questions on the back of the security brief.
You will respond, just for the record.
And I asked the deputy ranking member about it. Apparently, they are yet to submit those information to us, even though we've made a request. So it will mean that we can't ask you a question about your background from the security authorities. We'll wait for what they will bring, and when it comes in, if there's the need for us to ask you a question, we may have to do that. Maybe there may not be a need, but if there's the need, we may have to get that information.
I'll be grateful, but I would like to say that I have no criminal record. I'd like to put it on record.
And for the records, obviously we should have it so that we ask you some questions, and if we are satisfied, recommend for your approval. So we'll wait for those information. But let me ask you, as human beings, and judges are humans, like all of us, and humans are fallible. What do you consider as your worst judicial mistake during this period working as a judge? And every human being makes mistakes. Do you consider during these years whether you've made a mistake or not?
Honorable Chair, sitting here, I can't, off the top of my head, remember worst mistake in my judicial career. I can't, off the top of my head, remember anything of that nature.
Honorable Nominee, how many years have you worked at the bench?
Honorable Chair, 25 years. 25 years, since August 1998.
25 years is quite a long time, and you think that you've not made one single mistake in 25 years?
It's a question. No. What I said was that I can't, off the top of my head, remember. It's possible I must have done something, but I don't. As I sit in here, I can't, off the top of my head, remember any such mistake.
That's exactly the point.
There is an issue that is of concern to most Ghanaians, the issue of judicial corruption. As a judge, an experienced one, of course, with 25 years standing, what will be your recommendation to us how the nation should approach the issue of judicial corruption?
Well, Lord, I'm reminding him that it will be the fourth time you're answering the same question. So try to be as brief as possible. Your answers are already on record.
Okay, corruption, it's difficult. What we as a judiciary can do will be to set in place the institutional framework, like a complaints unit, and announce to people that don't give out money when you are coming to file a process, apart from the proper fee that you have to pay, and don't pay money to staff of the service, don't pay money to anybody. Those are the things that we can do, because it is difficult to know who walking around the court has a criminal intention. It's difficult to know. That's all, because the thing is in the mind of people. If somebody wants to be corrupt, it's in his mind. He wants to be corrupt. You cannot tell whether this is a corrupt person walking around. That's what makes it difficult to. But if you are caught, given the structures that have been set in place, then the institution has to deal with you harshly, if I may add.
Will you recommend prosecution of judges if found to be corrupt? Will you recommend prosecution?
If the evidence is available. Because, as I always say, everything depends on evidence. I know that there's evidence that one or two judges have been sentenced in the past when the evidence was available. If the evidence is available, why not? The judge is like anybody else. He can be prosecuted.
In your earlier answer to a question posed by the Honorable Judicial, the MP for Wa Central, Wa West. You said that out of the cases that the judges sit on, only about 5% are deemed political. And only about 5% of the judgment are deemed political or are political. May I ask you, are there political judges?
Honorable member, there are no political judges. There are no political judges. That is all that I'll say.
But they are political.
And it's dangerous to describe a judge as political this, political that. It's a very dangerous thing for a judge to even allow himself to be described that way. So I would say that there are no political judges. If a judge has to act according to his conscience and according to the oath that he takes, there are no political judges.
But we sometimes get political judgment. Is that the case?
Honorable member, if there are no political judges, there cannot be political judgments.
Thank you very much, Mr. Chairman. Mr. Chairman, that will be all. Thank you for the opportunity to ask you questions.
Just a quick one. There's a reason we look for the report from the national security. Yeah, I'm surprised, even before we saw the report, you are claiming you don't have a criminal record. Are you not preempting what the other state authority should do? I don't know until I get one. So I think that the same way you don't want the public to preempt the outcome of your cases in court, allow the national security to bring their report so that we look into it.
Honorable Jogate, you may ask your question.
First of all, my lord, let me congratulate you. My previous interjections were not questions. I just was given the opportunity to interject. And I'm sure you are aware of Article 35, Clause 6B, and don't read it because I'll read it for you. It says the state shall take appropriate measures to achieve reasonable regional and gender balance in recruitment and appointment to public officers. And it's not like that I congratulate you. I believe you'll be the only person from the Western region on the bench. And so it's not like that I congratulate you. And I wish you the best. And it is in line with the constitutional edict that there should be reasonable regional balance. So congratulations, my lord. Now, secondly, well, you said there was attention for Western region, but there's been a Supreme Court judge for Western.
Ask your question.
Mr. Speaker,
I'll take your opportunity.
this Mr. Your member is
him.
I should ignore him. Yes. Okay, Mr. Chairman. The second question I asked is that you've been in this business for the past 25 years, and so you remember the era where we're doing oral submissions. When I came out of law school, people like Peter Lajete, Joe Randolph, E.D. Combe, Nana Akufo-Addo, the current president, Nome Kujewu, Kwame Tete, and I can go on and on. If I left somebody's name out, it's not that the person was not good enough. But when we heard that they were arguing in court, we will go and listen. We will sit down and listen. The court will be full because great minds are speaking. And indeed, we learned from them. You go to court and you learn. You sit down and listen. And that's why, as a junior, I believe that's one of the reasons why your cases are called last. Because as you sit down, you hear things. You are learning. Just now, for some strange reason, everything now is written submission. For me and Honorable Joe Seusu, who have practiced for 30 years and above, what is happening is strange to us. When we tell our juniors to work in a particular way, they say, now this is not the way we do it. I agree that the courts are busy and everything. So maybe that's why you did this. But what is happening to advocacy? You written submission. I hear that when you go to court, the judge even asks you to talk for 2 minutes or so. And why? What is happening to advocacy?
I remember that is part of the processes we have adopted to reduce time in terms of delay. Honorable Seusu was in Kumasi. There was a lawyer called W.K. Dapa years ago.
He's from Bequio.
If he had to address a court, they would carry his books in a Ghana Must Go bag. And Honorable Mr. W.K. Dapa would take 3 or 4 days.
His chambers was called Otutu Chamber.
So, obviously, we can't continue like that. The WK Dapa sort of practice. We can't do that.
About the Joe Randolph, the Kwasi Aiden, the Peter Lajete kind, they don't bring a gun to which they don't shoot. They speak law, and we listen. Just now, if Honorable Joe Seusu goes into court, nobody will hear him. And if they heard him, they will learn something. If I go into court, they won't hear me. If they heard me, they will learn something. So, I mean, you think that there can be no middle way? We should just silence all the lawyers?
No, it's not silent. You put everything on paper. In fact, it's even to your advantage. The judge reads it, and it is part of the proceedings. Sometimes if you talk too much, the judge may not even be sitting down, may not be recording. But if it's on paper, it is part of the process. And the judge will hard-working judge, we will read it. That's why we work in the night. You sit down and read the proceedings.
It's only reflection.
So I won't speak.
Yes. Thank you.
I see that you vehemently disagree with me. So we'll keep our views. One day, if I have some opportunity, I may change it. Thank you.
You know, it's a reflection of those who have expired. Our term, we must accept that our term has
great
expired.
objection to what you said. My Lord, I've practiced for only 35 years, and I intend to do 35 more years.
We are no longer in vogue, so we should accept that the new old school must give way to the new school. This argument I recall very well in 1993 at the back of Francis Second, when this matter came up about rating advocacy. And then the Akufo-Addo then was making a strong argument about forensic advocacy. Then lawyer Lumo said, what is forensic evidence? Your money. You take your money, you put your case across, what does long English? So now we have gotten to put your case down and take your fees. You and I, we have expired, we should accept that. My Lord, I have no more questions for you. I've asked a few questions previously. On behalf of the committee, we thank you for attending upon the House. You'll be discharged for now, but because our attention was drawn to, there are 2 reports we are still expecting from the security services. If the reports come and there's a need to recall you, we will. If we don't recall you, it means that there's nothing further to be investigated from. And then we will ask the Ghana Revenue Authority to explain to us how come a person who is paid every month and whose taxes are deducted at source every month is declared to be zero rated all through. We will ask Ghana Revenue to clarify that for us. So, my Lord, we thank you for attending upon the House. My Lord Chief Justice, I now acknowledge you and your team. I know you will wait till the rest of the others join us, but please bear with us. The Speaker has called that there's a function we must suspend proceedings here and participate in. As soon as we finish, we will come back. So I'll suspend sitting for 1 hour. We will come back after 1 hour. Thank you very much.
Honorable Chair, I'm very grateful to the committee for having the time to listen to me. I'm very grateful. Thank you. Thank you.
Achomi ni kwansa mejija seche mami ma gbeji ma mpehia wo ma na mi ye afi yo yakayaka ni ye ma mpehia ma na mi agbere wo bi unu ni ya school wo wumla age bumono le no ba wo beke yo ko ho ni school girl ni o ye fan mo ni o fan obo o fote o mishi agbene be na abe o abe ye ma na mi no mo na no ano ye ma na mi wo ke ni bi esue egbeno ojogban bonisa neke bejane to ne ni modromo na onne she action aid no be san mine ame wo wo egbe baba o no o neke na na ebi o ne ni kase mo strut wo to mo me ke o ameke weti workshop baba o me neke action aid committee ya kase saneyeli ye amasama wo ye manchema school ni action aid ke wo ya ye amasama da afi na kase o meni won pama bi fe fai Ghana fe fai ake bi na ke ha na ayafia me yaka ni bi ye afose no mi die no here ko ma ai chumba papa to mo gbele no gwani ke eyiyo nsane ba Facebook ake mu ko egbenga logo hule hu egbenwu won pa fa ake ka ma je ni bi e eyan.
GTV, the authentic and trusted voice of Ghana.
Yamam Official! The Speaker of Parliament, Right Honourable Alban Sumana Kingsford Bagwin, the Parliamentary Christian Fellowship, in collaboration with Ghana Broadcasting Corporation, is organising a festival of 9 lessons